5 seconds to go. Start. So, there is no necessary connection between the cases where police can arrest the accused without warrant and the cases where the magistrate could issue warrant of arrest against a person under section 73 of CRPC. The magistrate may not be authorized to issue warrants in a given case where even the police could have arrested such a person without warrant. On the contrary, the magistrate may be authorized to issue warrants even where the police was not authorized to arrest a person without warrant at all. Therefore, category C above has to be read in the same sense and as meant for the same stage of proceedings as are meant in category A and B above. Hence, it has to be held that under section 73 the magistrate can issue warrants against a person who is evading arrest only if such a person was required to appear before the court under some other past under some other provision like under section 87, section 89 or under the section 390 of CRPC during the trial or at the time of or after taking cognizance. This provision cannot be used only in aid of the investigation officer or for ensuring that such a person appears before the court and is handed over to the investigating officer. After all, the word non bailable is having significance only when a person comes to court to seek bail against his arrest and not otherwise. Still further, the investigating officer is under duty under section 41 to arrest a person unless he records reasons for not doing so. Hence, it is obvious that neither there is any necessity for a warrant of arrest for arresting an accused during investigation, nor has the court been given any specific power in this regard by any specific provision of CRPC. As a corollary to the above, it is also clear that before filing report under section 173, the police cannot get a warrant of arrest against a person without any specific reason, and therefore a person cannot be declared as a proclaimed person or offender in routine by following procedure under section 82 of CRPC only because despite having power to arrest an accused, the police had not succeeded in arresting such a person or might not have chosen to arrest such a person. Accordingly, having heard learned counsel for the parties and having perused the file, this court finds substance in the argument of learned counsel for the petitioner. As discussed above, provisions of section 41 of the CRPC are quite clear that unless a cognizable offence is committed by a person in the presence of such police officer cannot arrest an accused only on the basis of his whims that he suspects the said person to have committed some offence. If such person has committed such cognizable offence which is punishable for imprisonment, Then, before arresting the person, the police officer has to satisfy himself that the arrest of such person is necessary for the purposes delineated in the section itself. This court finds reliance of the counsel for the petitioner on Arnesh Kumar versus State of Bihar and another 2014 8 SCC 273 befitting in the facts of the case. In that judgment, the Honorable Supreme Court has unequivocally held that before arresting the accused alleged to have committed a cognizable and non bailable offence punishable with imprisonment up to 7 years, the police officer has to record reasons qua his satisfaction that the arrest of the said person is necessary for the purpose mentioned in the section. As a necessary corollary, this would mean that if the conditions mentioned in these provisions are not complied with by the investigating officer, the arrest of the petitioner from very inception may be rendered invalid, inviting the adverse legal consequences even for the concerned police officer. To clarify further, the Supreme Court has also said that even at the time of authorizing detention of a person who has already been arrested by the police, magistrate would not go by ipsi dixit of the language which might be reproduced in the record of the police. He has to apply his independent mind as to whether the reasons are sufficient to sustain the satisfaction qua requirements of getting such person arrested. Only if the reasons are found sufficient, the person arrested by the police can be authorized to be put in further custody of the arresting officer. Still further, in case of judgment, in the case of Daud Ibrahim Kaskar Supra, the Supreme Court has dealt with the language of section 73 of CRPC and has explained the situation in which the magistrate can issue warrant of arrest as observed above, although the bare language of the section read as it is requires as a precondition for the issuance of warrants by the magistrate only this much, that the person is evading the arrest. However, even this has been interpreted by the Supreme Court. It has been held by the Supreme Court that no arrest will be made. Stop.